G'day, Stephen Page from Page, Prohibited Family and Fertility Lawyers, and today I'm talking about something that's about to happen that makes no sense at all, and that is by October, Australia, with a population of 27 million, will have 7 systems of regulation of IVF clinics. Just think that through. 7 million in a population of 27 million. We've got about the population of Shanghai. Shanghai apparently has about 26 million, and of course they don't have 7 systems for that one city. But we do, because we're going to have different central donor registries in Queensland, New South Wales, the ACT, Victoria, South Australia and Western Australia. And we're going to have, actually I might be right, it might be 8 systems, might be 8, I've got my numbers wrong. I was a lawyer, maths weren't my forte, because we're going to have an Assisted Reproductive Technology Act in Queensland that I anticipate will be enacted well and truly and come into place by October. We have the Assisted Reproductive Technology Act in New South Wales. We have an Assisted Reproductive Technology Act in the ACT, which has been enacted and I anticipate will come into effect in this part sometime between now and March 2025. We have the Assisted Reproductive Treatment Act in Victoria. We have the Assisted Reproductive Treatment Act in South Australia, and we have the Human Reproductive Technology Act in Western Australia. And Northern Territory derives itself in part from the South Australia, although it doesn't have formal rules. It relies on the National Health and Medical Research Council ethical guidelines for assisted reproductive technology, and Tasmania still has the ethical guidelines as their basis. So 8 rules. I said 7, but it's actually 8. 8 systems for 27 million, and it's crazy. And when we look at the IVF industry in Australia, we have a very concentrated industry with IVF clinics going across state borders. And if we look at the 5 biggest clinics, they are Virtus Health, so that's Queensland Fertility Group, IVF Australia, Tas IVF, Melbourne IVF. And the second is Monash IVF. The third is Genea Fertility. And Genea, for example, operates in Queensland, New South Wales, Victoria, ACT, South Australia and Western Australia. And the 4th largest is City Fertility, and the 5th largest is a cut price Adora Fertility. They operate across state borders, and so each and every one of those has to make sure that it's compliant with the law of this place, which is not the same as the law of the neighbouring state, or the one down the road, or the one across the continent. So their compliance costs go up, both internally with the employment of staff and with the engagement of outside legal advice and audit people, people like me. Those extra costs, believe it or not, get passed on to consumers. So the idea that we have 8 systems in 27 million, what that's actually doing is driving up the costs for consumers. The number one complaint by consumers is the cost of IVF in Australia when it comes to IVF. So what do we need? We need national, consistent laws dealing with regulation of IVF in Australia. Now, whether that's state by state or Commonwealth, I don't particularly care. But the idea that we have all these donor registries and not talking to each other and different regimes of regulation state by state is just simply crazy and adds to consumers' costs. It's got to stop. Thank you, Stephen Page from Page, Prohibited Family and Fertility Lawyers.